hear him.
We can't hear him.
I've got my mute off. Hang on.
Okay, there you go. We can hear you now.
Yeah.
Okay, very good.
Okay. Can you introduce yourself, please, and tell us your background, please?
Sure. My name is John Eastman. I'm a professor of constitutional law and former dean at the Chapman University Fowler School of Law. I'm also serving this year as a visiting scholar at the University of Colorado at its Benson Center, and I'm a senior fellow at the Claremont Institute.
Thank you. Professor Eastman, I believe you're going to talk to us today about the Electoral College process and how that affects the legislature here.
Sure. Thanks very much. And Chairman Ligon and the members of the subcommittee, thank you for inviting me to testify at this very important hearing. My scholarly work and expertise have always revolved around the structural provisions of the federal Constitution. And because of that, similarly, 20 years ago, I was invited to testify before the Florida legislature as they were dealing with issues similar to what you're dealing with now. At that time, no one had given much attention, scholarly or otherwise, to the role the Constitution assigns to state legislatures in determining the manner of choosing electors. And it's a little bit foreign to us now because we haven't really done what the Constitution authorizes fully for a very long time. The last time the issue really came up was in the election of 1876, and I don't think any of us, maybe Mayor Giuliani, I don't think any of us were around back at that time. But in the wake of that controversy, Congress passed the Electoral Count Act of 1887, and which aimed to clarify some of the processes. That act, too, didn't get much attention until the 2000 election down in Florida. And before we really got into the intricacies of that act, the Supreme Court's resolution of the case in Bush versus Gore kind of ended the matter. But since then, there's been a whole lot of scholarship done. And most of it is confirmed with the written testimony I gave to the Florida legislature there. And it's that process that I want to focus on. Let me begin with the relevant provision of the U.S. Constitution that, Ray, you talked about earlier in your testimony this morning. Article 2, Section 1 provides that each state shall appoint in such manner as the legislature thereof may direct a number of electors to which they're entitled. The Supreme Court has described this constitutional authority of the state legislatures as plenary. That means it knows no other limit. That the legislature gets to do what it wants. That was in a 1892 case called McPherson versus Blacker, and it was reiterated by the Supreme Court in the Bush versus Gore case back in 2000. It even is noted that whatever provisions may be made by statute or by the state constitution to choose electors by the people, there is no doubt that the federal Constitution gives the right to the legislature to resume that power at any time. That's again McPherson, and the Bush versus Gore decision reiterated that. In the early decades of our nation's history, most state legislatures selected their state's presidential electors themselves. Only after 1824 did a majority of state legislatures move toward choosing their electors by popular vote. But your neighboring state legislature up in South Carolina continued to choose its state electors by itself all the way up until 1860. Nevertheless, the constitutional power to decide on the method for choosing electors remains exclusively with the state legislatures. Now, to be sure, the authority to take back that power and appoint electors at any time, as the Supreme Court said in McPherson, would likely not allow a legislature to pick its own slate of electors after the results of a fair election, which had been conducted pursuant to the legislature's existing statutory procedures, merely on the ground that the legislature didn't like the outcome that the popular vote had chosen. As the Supreme Court said in Bush versus Gore, when the state legislature vests the right to vote for president in its people, the right to vote as the legislature has prescribed is fundamental. But that's not the case when the existing procedures are not followed. And when significant statistical anomalies and other evidence raising serious questions about voter fraud and about whether the election was fair. In such cases, the manner for choosing electors set out by the legislature was not followed. The constitutional default of the legislature exercising its plenary power, or rather resuming that power, is therefore again brought to the forefront. As the court noted in Bush versus Gore, the right to vote in election for presidential electors is fundamental when done in the manner the legislature has prescribed. Now, what you've been hearing today is a lot of testimony about how the statutes that you had prescribed for the manner of choosing electors were not complied with. By the way, this is all in perfect line with federal statutory authority as well. Section 2 of Title 8 provides that whenever a state has held an election for the purpose of choosing electors and has failed to make a choice on the day prescribed by law, the electors may be appointed on a subsequent day in such manner as the legislature of such state may direct. The failure of state election officials to follow the manner you had set out in statutes in conducting this election, as well as the intermingling of illegal and legal ballots in significant enough numbers that the election can't be validly certified, quite simply means that the state has failed to make a choice on election day in accordance with the manner that you've prescribed. And the appointment of electors, therefore, both under Article 2 and Section 2 of Subtitle 3, devolves back on the legislature of the state, which has plenary power to decide whether and how to exercise the appointment power itself or craft some other mechanism to cure the problems with the state election that occurred. That is what the Florida legislature was prepared to do in 2000, prior to the resolution of that state's election controversy back in 2000. The vote on that day had been certified by the Florida Secretary of State, but the state Supreme Court had, contrary to state law, ordered a recount in only heavily Democrat counties with the expectation that that would flip the vote that had been certified. The relevant committees in the Florida legislature, both houses, crafted identical resolutions that would allow the legislature to reclaim its plenary power of choosing its own slate of electors. Those resolutions passed out of the relevant committees, and they were already scheduled for floor votes where they were expected both to pass when the Supreme Court issued its decision in Bush versus Gore, making that unnecessary. Violations of Georgia election law here, which is to say the manner that the Georgia legislature has established for choosing president electors, are numerous. As you've been hearing testimony all day today, the number of underage individuals who are allowed to register contrary to the statutory authority amounts allegedly up to approximately 66,000 people. 2,500 people who are convicted and incarcerated felons were allowed to vote and have those votes counted contrary to state law. Proofs of identity that are required under state law were not complied with. Voters, as you just heard, moving from one county to another before a 30-day window, as the statutes allow, were allowed to have their votes counted and cast in the prior county of their residence, contrary to state law. A number of voters don't even have registration of residential addresses, but P.O. boxes, and have been allowed to vote and cast ballots, contrary to state law. I think the biggest one is a result of the March 2020 settlement agreement that was entered into with your Secretary of State and certain Democrat committee challengers that effectively altered the signature verification process for your absentee ballots in ways that are contrary to state law. Those state statutes are all designed to help prevent fraud, and yet their violations now then have created a serious problem with the potential for fraud. Just on the absentee ballots itself, the signature verification process normally results in the rejection of about 3 to 4% of absentee ballots for failing to include a residential address or for signatures that clearly do not match those on registration. Because of the changed procedures as a result of that settlement agreement, and that was agreement that was entered into without any involvement of the legislature, which means it was done contrary to the U.S. Constitution's authority in Article 1, Section 2. The rejection rates in this election were like 1/3 of 1%. With the resulting about 40,000 ballots that would have been discounted or rejected historically were allowed to be cast and counted. That's a significant deviation from the manner that this legislature has set out. These significant statutory violations are, in my view, more than enough in the way of the alteration of the legislature's approved manner of choosing electors to warrant this legislature from taking back its plenary power to determine the manner of choosing electors. You could do that by calling a special election, although the time is very tight for that and may be logistically impossible. But you could also do what the Florida legislature was prepared to do, which is to adopt a slate of electors yourself. And when you add in the mix of the significant statistical anomalies and sworn affidavits and video evidence of outright election fraud, I don't think it's just your authority to do that, but quite frankly, I think you have a duty to do that, to protect the integrity of the election here in Georgia. These violations, combined with the significant evidence of fraud, in my view, strongly support the conclusion that something is amiss here, and that the legislature simply must investigate, as you're doing with this hearing today. And then if as a result of this investigation, you're convinced that the election was conducted contrary to state law and too fraught with the risk of fraud to be properly certified, then you should exercise your prerogative to legislatively designate a slate of electors more in line with what the evidence of what actually happened on election day by valid votes demonstrated. Now, I also think it's important that this legislature take the action before next Tuesday, December 8th. And my apologies, I have a typo in my written testimony that I provided that said December 6th, because that's when this deadline for taking advantage of safe harbor provisions in federal law, Title III, Section 5 of the U.S. Code, kicks in, but certainly before December 14th, when the electors are designated by Congress to meet and cast their votes. Only by such action can this legislature protect Georgia's right to choose electors for the election of president and vice president in accord with the statutory manner that you had set out well in advance of Election Day on November 3rd. And it's those electors that you decide need to be established that should be counted by a joint session of Congress, which begins at 1 p.m. on January 6th in 2021. Thank you very much for your attention. I'll be happy to answer any questions.
Okay, are there any questions?
Thank you, Professor Eastman.
Senator Parent has a question, and you're on number 6.
Yes.
Yes.
Can you hear me?
Yes, I can.
Oh, good. Thank you so much for being with us. I find all this a very interesting constitutional argument. So correct me if I'm wrong here, your argument is that essentially we have a failed election that would require the legislature to step in and assign electors. Am I correct?
Yes.
And what do you say in terms of proving that there's a failed election? What do you say to what's been laid out by our Secretary of State, Governor, Attorney General Barr, and the courts? Because right now there have not been, as far as I'm aware, proof of the number of ballots that would be required to have been problematic to switch the election and call it a failed election. I don't know where the evidence is. What do you say to that?
Well, there are two issues here. There's one, this extent of the fraud in the casting of ballots, and the other, which is undisputed, the failure to comply with the statutory scheme that this legislature had sent out. You can say that there's no fraud whatsoever, but if the statutory scheme is not followed, the manner of choosing electors set out by this legislature, which has the sole authority to decide what that manner is not violated. It has been violated. Okay. And therefore the election is invalid, even without any evidence of fraud.
Well, can I ask you what is the statutory scheme that, in your opinion, was not followed?
Well, I recited several of the provisions of the state statutes that were not complied with in my testimony.
I don't have your testimony, sir. I apologize.
Yeah, no, that's all right. So I think the biggest one was the change in the signature verification process on absentee ballots. That was done as a result of a settlement agreement.
I'm aware
that did
of
not
that.
invoke the legislature.
Right.
Now, the problem with that is you had a judiciary and you had executive officials changing the statutory mechanism. The only authority to do that is the legislature.
So I understand
and the legislature did not do that.
I understand the argument. Can I, and I apologize for interrupting. I just want to get sort of the things I'm really focused on answered. So the Secretary of State's position is that the law was not changed. They just, essentially, they said, this is how we're going to do it to ensure uniformity under the law through guidance to the counties, and the law wasn't changed.
Well, I mean, I've looked at the statute and I've looked at the consent decree, and the consent decree very clearly allows signature verification only of the signature on the application for absentee ballot, whereas the law requires signature verification of both the signature on the application and the signature on file with the registration card.
But sir,
That's,
isn't
that,
that what we
or
did?
that change from or to and is a significant
Okay.
change.
I do believe that the procedure is you check them both, so there's signature verification 2 times.
Not according to the consent decree. It says or. It says or, and that's a significant change over the statutory scheme. It's only one of the significant changes.
Okay, but wouldn't you agree
that I
that's-
recite in my testimony.
But would you agree that if the procedure is that they check it twice, that's actually preferable?
Yes, that's what the statute requires.
And I believe
but the
that's what
consent
the-
decree allows it to be checked only once. The statute has a double protection there. The consent decree only has a single protection, and that's a change from the statutory protection against fraud that the legislature had adopted that was not complied with.
Well, you and I have I'm not sure that's correct. I think it's checked twice, and I think that's what the guidance said. But can we move on? And what else was statutorily not followed that, in your opinion, resulted in a failed election?
Section 21-2-216 on registration of underage voters. They're allowed to do that up to 6 months before they turn 18, if they will be 18 by the time of the election. That was not complied with. People were allowed to register to vote more than a year ahead of their 18th birthday. That looks like more than 66,000 people were illegally allowed to register and vote in violation of that statutory scheme. Felons were allowed to vote in violation of the statutory scheme. The failure to check voter identity was, requirements of state statutes were violated. Those violations of the state statute, and let me give a comparison. In North Carolina in 2018, in the congressional district number 9 there, somebody violated state statutes by doing ballot harvesting that was not allowed under Florida law. Nobody demonstrated or proved that any of those harvested ballots had been illegally cast by people who weren't proper voters. Mm-hmm. Nevertheless, the violation of the state law was enough for the state election board to order a re-election as a result. I think the same thing has gone here with these violations of the state statutes.
And if I may very briefly wrap it up. Yeah, thank you, Mr. Chairman. I'm aware of the North Carolina situation. I think the difference that at least I feel is I haven't seen any evidence of any of the things that you're talking about. So we would need some sort of court intervention. We would need a successful lawsuit. We would need the state elections board to take action the way you described happened in another state. And right now what we have is in our law 21-2501F, where the legislature has decreed that the candidate receiving the most votes is who the electors will represent. That's what we have in our law.
Well, with all due respect, the candidate receiving the most votes in an election conducted in accordance with all the other provisions of your state election law. When that was not done, you don't have a valid election. And this is exactly what happened in Florida when the state Supreme Court started ordering things on recounts that were contrary to state law. The Florida legislature didn't wait for a determination of a court to say our state law was violated. They made that determination themselves and passed resolution to protect their electoral votes. I mean, and it is their sole authority under Article 2 of the Constitution to do that.
So there's a lot of fraud that even the Attorney General of the United States has not found? I'm confused. I'm sorry. And
Well, no, you went back to the very first point you made. There doesn't have to be evidence of fraud, although I think there's rampant evidence of fraud, as you've been hearing all day today. The mere violation of your state statutes is sufficient for this to be an invalid election and to return the power to determine the manner of choosing electors to this body.
Senator Jones.
Dr. Eastman, it's Burt Jones, Jackson, Georgia. Appreciate you being here today. And I appreciate you educating the members of the committee here on constitutional law, which I'm sure most of us needed to hear. But with the argument that we've been presented as far as the irregularities with the voting and also the consent order that our Secretary of State went into as well back in March. With us also having another election coming on the horizon on January 5th, with all these questions swirling around the November 3rd election, wouldn't it be in our best interest to try to correct these things as a legislative body before the January 5th election runoff?
I do think it would be in your interest and the interest of the voters of Georgia to fix this, to make clear what the statutes say. And when the consent decree, if as I read it, is contrary to your state statutes, to determine that consent decree has no validity over the operation of the legislature. The executive officials don't have authority to constrain the manner that you, the legislature, have chosen, because that power is given to you as a plenary power by the federal Constitution. And what the Supreme Court said in McPherson is not even your state constitution constrain your authority on that. So certainly a consent decree entered into by the Democrat Party and your Secretary of State can't constrain the manner that you have set out for choosing electors. And if I'm right that the consent decree violates those state statutes, it's the state statute that is supposed to govern.
Thank you, sir. I appreciate you being here and answering our questions.
Senator Dolezal.
Thank you, Mr. Chair. Should have that memorized by now, probably.
That's right.
Dr. Eastman, thank you for joining us. I want to unpack this settlement agreement a little bit relative to what it changed in our law. And I think the operative word is actually any. And if you look on page 3 of the agreement, essentially what we did is we introduced new source material into the second signature check, right? So to reference what Senator Parent was saying, the two checks that are envisioned under our code should both be checks against the file the signature that's on file in ENET. And what changed in in the settlement agreement was to introduce something that the law never envisioned. It introduces into the second signature match that is on the ballot, the actual absentee ballot envelope, to compare that and to allow the original signature that was on the absentee ballot request form to all of a sudden become source material, and that we only now require it to match any of the voter signatures on file in ENET or on the absentee ballot application. Our law never envisioned comparing the signature on the ballot with the signature on the ballot application. So essentially what we did was we ignored the double check, because by allowing the first check to essentially match the second check, we only have one check. And the law, to Senator Parent's point, should have two checks against that signature that's on file in ENET. And if we wanted to change that, then we should have dealt with this in June when we were sitting in this building to continue our session this year, and we could have had that debate. But what happened here is a fundamental shift in the signature match process that was passed by this legislative body, and it does fundamentally change the source material and essentially moves it from two checks down to one check. So I know you said that the operative word is or. Really, the operative word is any. That we're now only requiring a match of any signature, not the signature that the statute actually calls for. And there are other things in here that were added procedurally that may be good procedure. But to your point, and I guess this is my question, what do you view in your legal opinion as the bounds by which an executive branch member or a secretary or even a governor has the ability to kind of unpack in guidance and change any shall language or specific language versus their ability to kind of operate within things that are more loosely defined in the code?
Well, kind of clarifying what they view the statute as meaning is, I think, normal part of interpretive regulation. But when they change the manner, and I think, allowing for any signature means I could match it against your first voter registration card, I could match it against your latest registration card, or I could match it merely against the application. Of course, that means if somebody is fraudulently submitting applications in the manner that you heard testimony of just about an hour ago by that college student named named Grace, and I'm sorry I don't recall her last name, that somebody submitted an application on her behalf and voted it on her behalf. Now, if the signature on that ballot when it came in had to be compared with her voter registration card, the fraud would have become manifest. But when all it had to do was be compared to the application, then the double fraud, both on the application and the vote, gets through, and she could be deprived of her right to vote as a result. The second thing they did with that settlement agreement is the statute says, one election official is supposed to determine whether an application for an absentee ballot is valid. It created a higher burden by requiring 3 people to review it. That may be good policy or not, but particularly in light of the massive increase in number of absentee votes, what it did is induce people to be much less careful in the validation process that they were even doing. And it was a looser process than your statutes allow. So I think on several fronts, that settlement agreement is contrary to your state statutes.
Wait a minute. Senator Brass, did you have a question? He raised a question. All right. Go ahead, Senator.
Thank
I
you.
recognize you.
So, Professor, I disagree with you in terms of your interpretation of the consent agreement, but we're going to kind of move on from that because I do want to talk about the whole idea of this check, that somehow it's a fraudulent check if you compare the ballot signature to the application signature. I just want to focus on that. You are aware that under Georgia law that the application signature has to be checked against the original registration card or the most current update that the Board of Elections has. Do you understand
I'm
that?
aware of that as well. But one of the allegations that has been made is that because of the massive increase in number of absentee ballots and the increased burden on county officials by going from 1 official to 3 in order to validate that check, that meant that process was not being faithfully complied with, which makes it even more important that the double check that your statute sets out, both on the front end when the application is filed, but also on the back end when the ballot is filed, is submitted, that it be checked against the original voter registration signature or the most recent voter registration card on file.
And respectfully, Professor, but with respect to that allegation that somehow this need to increase kind of eyes on a signature to make sure that it's a valid signature, that somehow overwhelmed county elections offices and prevented them from actually being able to do the appropriate check in terms of a signature match. That's just an allegation that has absolutely no evidence attached to it. Isn't that correct?
Well, it's been an allegation that's been made. I'm not here to talk about the evidentiary proof of it. What I can confirm is that the settlement agreement doesn't, the statute requires the check against the registration signature at both phases, the application phase and the ballot verification phase. The settlement agreement allows that signature verification to be done either against the registration signature or the application signature. There's a double check built into the statute. There's only a single check built into the settlement agreement, and I think that violates state law.
One final. Professor, are you a member of the Bar of Georgia?
No, I'm not.
Okay, thank you.
I'm a member of the 11th Circuit Bar, which has federal authority over Georgia, and I'm a member of the Supreme Court Bar.
Thank you. Ms. Smith,
Thank
are any other questions? Okay. Yes, Mayor, please, Giuliani.
Professor, it's Rudy Giuliani, who does remember that election in 1876.
Sorry about that, Mayor.
Vaguely. Professor, is it possible for the legislature, if they assume the authority that is theirs under the Constitution, could they make findings?
They could, of course.
Fact, based on
They could make
for example,
based on the investigation they've conducted today.
They had evidence presented today. They've had affidavits presented today. Assume they had fulsome evidence of 3 or 4 violations. Could they make those findings?
They could. And I would encourage them, if they were to take this step with the resolutions I have recommended, that they preface the resolution with a set of findings.
And Professor, what, presumably, action like this will be challenged in the Supreme Court. Should they take this action or some other legislation? How do you see that argument?
Well, it could get to the Supreme Court, or it could be presented to Congress at the joint session of Congress when they begin opening the ballots and counting the ballots. And if you have the governor's certified slate of electors and a legislative certified slate of electors, unfortunately, Section 15 of Title III is embarrassingly ambiguous about which of those slates of electors ought to be counted. And the 12th Amendment is also a bit ambiguous about who has the final say-so in making that determination. I think a very credible argument can be made that it's the President of the Senate as the presiding officer of that joint session of Congress. The rest of the two houses are supposed to be there to observe, according to the statute and the 12th Amendment. But of course, this is an unresolved issue, and there's scholarship going both directions on that question. And I think at that point, given the confusion of both of the 12th Amendment and the federal relevant statutes, I think the Supreme Court may very well weigh in.
Now, if they do, in fact, have a rational basis for their decision, either based on the law, as you pointed out, or based on factual findings as well, isn't it likely, assuming that that's correct, that the Supreme Court would recognize the power that was been granted to the state in this area and give it some degree of deference?
I think based on the McPherson decision and the Bush versus Gore decision, both the majority per curiam opinion and the concurring opinion by Chief Justice Rehnquist, the late Chief Justice Rehnquist, that would be where I would suspect the majority of the court would go.
Thank you, Professor.
Thank you.
All right. Yeah, Senator Heath.
Thank you, Mr. Chairman and Professor. Thank you for your presentation.
I'm sorry, one last.
Okay.
One procedural problem that they have is they need to have a special session. Now, given the fact that this power that they have comes from the Constitution of the United States, is that guided by procedures that would govern Florida law? Or could they call a special session?
Georgia law.
Georgia law. Or did I say Florida?
We're going back 20 years.
Bush v. Gore. Oh, my goodness. Yeah.
So I mean, we've not had that precise issue confronted as a holding, but in the McPherson case, the Supreme Court specifically said the legislature has plenary power, and even the state constitution cannot restrict that power. So if there's some provision in the state constitution that says you can't call a special session in order to exercise powers you have from the federal constitution, I think the federal constitution trumps that, and I think the Supreme Court's decision in McPherson supports that conclusion.
I agree that it trumps it, Professor. All right. Thank you, Professor.
Thank you.
Senator Heath, now you can ask your question.
Thank you, Professor. I'll just give you a little preface here. I'm just a cowboy from West Georgia, so this has been interesting, but I think the mayor just touched on the question that I was going to ask of you. So our Constitution, I believe, states that there's two ways to have a special session. One is the governor calls a special session for a specific list of or a specific purpose, or the legislature by 2/3 vote of the two bodies can call itself into session. Now, this appears to be a partisan issue. We certainly don't have a supermajority in either party here in Georgia. So am I hearing you correct that a less than a supermajority of the legislature could convene and appoint electors based on their findings of fact that the election was flawed and unacceptable?
I believe so, and I think look, the federal Constitution is going to prevail over limitations on your legislative power. Those provisions of the state Constitution deal with the state legislature acting in its state legislative capacity. But in deciding on the manner of choosing electors, it is not acting as a state body. It is acting as the federally appointed legislature with direct authority from the federal Constitution, which of course preempts the state limitations on it. And that's what the Supreme Court held in the McPherson case. That's what Section 2 of Title III provides in the federal statute. Whenever any state has held an election for purpose of choosing electors and has failed to make a choice on the day prescribed by law, and I would say in accordance with the law that had been set out, the electors may be appointed on a subsequent day in such manner as the legislature of state may direct. That's Title III, Section 2 of the U.S. Code. I think that also prevails over any other limitations that might exist in Georgia law about when the legislature can call itself into session. It has a federal statutory authority to deal with the issue when the state's election has not been validly conducted.
Thank you.
So, someone else have a, Senator Rett.
Doc, here's Senator Rett. Just one quick question.
Wait a minute, hey, let me get you cut on.
Two.
Yeah, all right, now you can go ahead.
Senator Rett, Doc, just one quick question. If the courts rule that there hasn't been a significant amount of evidence found to move forward with this, wouldn't this be in direct conflict with the Judiciary?
I'm sorry, if the courts rule that there hasn't been evidence of the fraud or hasn't been evidence of violations of the state statutes?
Right, not enough substantial evidence, then how could the legislative body move forward?
Well, so I think it's important to disaggregate two kinds of things. We're talking about evidence of fraud that was substantial enough to have affected the results of the election, or are we talking about evidence that the state statutes themselves were not complied with? And I don't think you have to have both. I think either one is sufficient for the legislature to resume its authority under Article 2 of the federal Constitution to make sure you have electors chosen in accord with the manner set out by the legislature.
Thank you.
All right, thank you. I think that may be all of the questions. Thank you, Professor, for your time today. It's been very enlightening.
Thank you, Mr. Chairman.
That's right.